So it's easy to read this law and hear some of the media coverage and think, oh, this looks compassionate. You shouldn't punish people for their pasts. On one part that makes sense, right? A woman shouldn't be blocked out of the job market for a mistake she made maybe when she was a teenager. But that isn't what's happening with this law. What it's doing is targeting pro-life organizations and making it harder for them to have ideological consistency, save lives, and show women in vulnerable positions they have more options than abortion. This is not a compassionate effort to prevent discrimination. It's a way to promote the lie that abortion is the best and only option for women.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofit organizations. So this week we'll be covering China's criminal sentencing of Jimmy Lai, which we've covered in the past, but we're going to go over it because there was a big development. And we're going to turn to California and talk about a really interesting showdown between the California Attorney General and the federal government over a California hospital that has decided to stop harmful sex-rejecting procedures. And then we'll finish in Michigan with a recent lawsuit filed by Michigan Right to Life over Michigan's ever-expanding non-discrimination laws. So let's start with Jimmy Lai. This is not a deep legal analysis because it's Chinese law. It seems to be a political prosecution, but we wanted to highlight it because it is still an important issue that a lot of people are talking about. And Jimmy Lai is both an advocate for democracy and open government and also a Catholic, so of particular interest to our listeners. So Jimmy Lai, just for background, if you are not super familiar with his case, he escaped from Maoist China at the age of 12. He comes from a Chinese family, grew up right before the communist takeover of China. He founded a massively successful journalist publication called Apple Daily, was a pro-democracy group, openly critical of Chinese policy on many issues. Interesting to note that Lai is actually a British citizen, and I think was repeatedly advised before his arrest to leave Hong Kong, but would not do so. He was originally arrested on kind of spurious violations of national security laws that I think were quite new. I think the laws were kind of put in place, and he was pretty immediately arrested under them. He's been accused of organizing unlawful political protests and other disruptive and supposedly illegal political activity. So I mean, Lai has been one of the most prominent voices for democracy and human rights out of Hong Kong. He had been incarcerated for, I think it's been about 5 years now, since 2020. Again, this is a little bit mysterious to me how the Chinese courts and processes go because the trial was years ago. He was being sentenced a couple years ago. So it took a really long time. He was just sentenced, which brings this back into the news cycle. And he was sentenced under China's national security laws to 20 years in prison for expressing his views and organizing political activity and doing political reporting in Hong Kong. So Lai is 78 years old. So a 20-year prison sentence is obviously problematic and means that he's likely to die in prison if there's no intervention. It's also worth noting that it's not just that he's incarcerated, but that the conditions are abysmal. Right? He's been largely in solitary confinement. His family, his son and his daughter have given reports on what's going on with Lai over the years. His daughter Claire recently explained that Jimmy Lai has not seen sunlight or breathed fresh air in quite some time. He's in really bad health. But Lai's daughter, Claire, in particular, has pointed out that he's been sustained by faith and by prayers. He's really living quite a Christian witness, almost in pretty much solitary confinement and abysmal conditions. To be, a man of prayer and hope in those conditions is really an inspiring thing. So what's going on here? It's not clear if there's, at this point, the remedy would have to be political and not legal, as far as I can see. And his case has attracted a lot of attention from world leaders. He's been, again, incarcerated for about 5 years. Conditions are terrible. Because Lai has been both an international political and media figure and also a prominent Catholic, his case has generated interest from leaders all over the world, including the current presidential administration in America, including the Vatican. There's been a lot of talk about Jimmy Lai's case. Marco Rubio recently, I believe, gave a statement drawing attention to this matter. There's been a lot of arguing from Western leaders for Lai's release, claiming this is a political and religious prosecution rather than a legitimate criminal case. But it's hard to know what the remedy or the way forward is. To be quite honest, I'm not particularly hopeful about this. I mean, Chinese officials are adamant that there's a prosecution that's completely legitimate, that he is violating laws by his disruption and his political um, disobedience, if you will. As There were reports that President Trump has spoken to China's President Xi Jinping recently about Lei. Trump is scheduled to visit China in the next couple of months. But again, China's doubling down. They're pretty adamant that there's a legitimate prosecution. And so I don't know what diplomatic ability there is to do anything here without causing, an international scene. And so obviously, America and China have tangled, complex relations, to say the least. Um, American media and American leadership arguing that Lei should be released as a political prosecution is a good thing to draw attention to it. But the reality is, how much political capital are you willing and able to spend to release a political prisoner like Jimmy Lai, short of imposing sanctions or going to war? I'm not sure how much can be done, nor do I think there's that much appetite to take the measures that I think would be needed to actually move the needle here. So again, not a lot to say legally. We continue to pray for Jimmy Lai. He seems to be living as a sacrifice for the faith and for freedom, right? He's living in these abysmal conditions and praying and maintaining his faith. So we should at least continue to pray for his release as well as for his perseverance in faith. Because it doesn't. I honestly don't know that he's ever going to get out. I think it's fairly likely that he will die in this prison. It's also an important case, I think, and I'll end with this to just draw attention to the darkness of many aspects of the Chinese political regime. Right, they're prosecuting a man for actions, whether they are in fact illegal under Chinese law or whether this is a political prosecution. I don't know. I'm not any kind of an expert in Chinese law, but these are clearly actions. What Lei has done in political protest, in journalistic reporting, these are clearly protected under the First Amendment here in the United States. So it just draws a pretty stark contrast about what we are able to do that is unpopular with the government regime, that is not a given in other parts of the world, and certainly not in China. So, Joseph, I'm curious to hear your thoughts on Jimmy Lai.
Yeah, Frank, thanks for explaining really a pretty somber but also inspiring issue. And we don't often discuss international affairs on this podcast. It's just kind of out of our expertise, especially when it comes to Chinese law or what may be seen as the lack thereof. But here the issue is so cut and dry and influential that it's definitely worth spending some time on. Like you said, Frank Lai is a man of deep Christian Catholic faith. Who was imprisoned by a government basically because of the content of his beliefs. And like you had mentioned, 20 years for Lei, he's 78 years old. That's effectively a life sentence. And really just taking this as an opportunity to ask for prayers for Lei and his family. A lot of reporting has been said that he's been denied basic human necessities. He's been denied communion. His family is really stressed, like you mentioned, that his faith has been the thing that's keeping him going. There's a great piece by Napa Legal's friend, Andrea Pacioti-Bayer, about how a crucifix that Lei drew while in solitary confinement is being displayed at St. Patrick's Cathedral. So it really is a beautiful testament of strength and faith amidst this persecution that he's facing. And like you said, Lei could have avoided the situation years ago. He was a citizen of Britain, could easily just moved and kind of avoided this whole thing, tried to do good advocacy from afar, but kind of being even aware of his circumstances and what may come from his advocacy. He stayed in Hong Kong and kept doing his work. So this whole experience really is a testament to the man's strength and his faith. So thank you to Jimmy Lai and really just prayers for his safety, both physical and spiritual, and for his family. So with that, we'll move into something that we are experts on, as opposed to international Chinese law, where we'll discuss a recent case in which the state of California is suing a hospital for ceasing the administration of sex-rejecting operations and drugs on minors. So the facts are pretty straightforward. In 2024, this hospital called Rady's Children's Hospital, called RCH, is based in San Diego. It merged with another hospital about a year and a half ago. Now, California law requires all merging hospitals to first receive permission from the Attorney General, and the Attorney General can impose whatever requirements he wants to as a condition to his consent on that merger. So in this particular instance, as a condition of providing his consent, California's AG Rob Bonta required RCH too, this is directly from the language of his conditions, continue performing, quote, gender-affirming care for the next 10 years. As we know, gender-affirming care looks like mastectomies on healthy girls, overdosing cross-sex hormones, puberty blockers, other irreversible procedures like this. And this is a children's hospital, so all these procedures are on minors, kids under the age of 19. However, recently, after kind of some federal action, in order to continue receiving federal funding, RCH said we're going to stop performing these procedures and administering these drugs. Now, before the merger, this probably isn't a come to the light moment. Before the merger, the hospital was one of the largest providers for these types of things. In fact, it was the largest in the Southern California area, and up until this point, had remained one of the biggest in the state. But because of these changing winds in the federal government, RCH said we're going to stop performing these things on kids. So Bonta's lawsuit claims that RCH is violating state law by breaking from his requirements that they had agreed to as part of this merger. And in this lawsuit, he's looking for an injunction that'll force RCH to keep administering these drugs and performing these procedures on kids, as well as a bunch of financial penalties. So there's two things I really want to add to get some color on what's going on here. The first is a little bit more technical, and I want to add some context to the type of law that California has in this area. And this is actually something Napa Legal has done a lot of research on. A lot of states in the U.S. have laws that require either notice to or consent from the state government before a nonprofit organization can take one of several major corporate actions. This could be voluntary dissolving, selling substantially all of its assets, mergers, amending internal documents, that sorts of thing. Some states have pretty minimal requirements that aren't super burdensome. For example, tell the state AG's office a week before you make a merger. Other states like California's are much more strict. In fact, California's law in this category is among the most burdensome in the entire country. In California, before a nonprofit can dissolve, sell all its assets, or convert its corporate entity type, it may need either consent or well in advance prior notice to the AG's office. Now, this particular instance here is a little bit different because we're talking about a hospital. They're kind of sometimes separate from a typical nonprofit subject to these laws, but the big picture still applies. And this case is a great example of why these laws requiring consent or notice to the government before a nonprofit can take some of these actions are really important, right? In the most burdensome states like California, activist attorney generals can condition their consent on the organization's following state ideology. That's what we're seeing here. On a smaller level, even just having to get permission from the government before you take an action adds more expenses to what could be an already really expensive process. So there's point one. These types of laws aren't exclusive to California, and they can pose a problem for nonprofits. And two, this is really kind of the bigger cultural point that we're seeing here. Is that this is the kind of thing that happens when we define these sex-rejecting procedures as healthcare. Governments are able then to enforce the execution of these procedures on minors. While I'm not an expert in medical law, from what I know, most hospitals are subject to some sort of regulatory oversight. The government wants to make sure that hospitals aren't, performing malpractice and for good reason. But if these types of operations, mastectomies on kids that don't need them, overdosing cross-sex hormones, if these are technically healthcare, then the government might have the legal authority to make sure that they happen. So we've talked before about how these things cannot, under any true definition of the word, be deemed healthcare. But if some states define them such, the state then can enforce this. So Frank, this is kind of what I'm seeing here, but I'd love to hear your thoughts on this too.
Yeah, no, that was you covered the substantive issue of these kind of quote unquote gender affirming care issues, and we use that term under duress because it's not gender affirming nor is it care. But what I want to talk about is the regulatory, the corporate governance issue here that is quite important. When Napa Legal added last year to our Faith and Freedom Index analysis the major corporate actions factor, which we encourage our listeners to go and look at, it was seen as kind of a little niche issue, like, why would faith-based nonprofits care about, what major corporate actions need approval by the attorney general? And this is an interesting issue. Like in this case, we're not talking about a faith-based nonprofit, so different regulations actually apply in California. But it's worth highlighting the importance of this. So there are quite a few states where before religious nonprofits, faith-based nonprofits take certain corporate actions, right? Merge with another nonprofit or dissolve and distribute their assets, or there are a few others, depends on the state. You actually need to either give prior notice or sometimes get affirmative consent from the state attorney general. And there are some cases where it makes sense. Like, for example, if a nonprofit is merging with a for-profit entity, it makes sense to have the attorney general take a look because now you have nonprofit assets that were, generated free of tax, donated free of tax that are now becoming part of a for-profit business. Yeah, that warrants a look from a government agency. No real qualms there. But when you're talking about two nonprofit organizations, both organized for religious purposes, merging or one dissolving and giving its assets to another, this seems to be more of a burden than an actual remedy for fraud or anything problematic. And it is a real burden. It can, if you have a nonprofit that's struggling and they have to wait 2 or 3 months in some cases before they get a sign off from the attorney general, before they can take any action, that might affect payroll. It might actually make them unable to make their expenses. It can be a real problem. And also, when you add discretion, like the California Attorney General has here, it's an added problem because there's a lot of discretion here for the Attorney General, as you said, Joseph, to require whatever the Attorney General wants to require before a merger can be approved. That kind of latitude is a problem, especially when you have maybe a politically motivated Attorney General, who in this case is going to require something like, um, you know, mutilation of children for a hospital to merge with another hospital, especially when you have this kind of showdown with federalism where the federal government is saying, well, we're going to condition federal funds on you not doing this. It can be quite a conundrum for the organization that needs to figure out how to merge with a more solvent or successful hospital. One note, too, that's interesting in California is that in most cases, the AG has a lot of discretion to do things like this, to create conditions, to give his approval before a merger can take place. But in California, most of these powers are limited when you're talking about an organization that is actually incorporated as a religious nonprofit under the separate code in California. So in that case, the attorney general still has some oversight capacity, but in California, my our vice chair John Pfeiffer will correct me if I'm wrong on this, but I'm pretty sure it's correct that a religious nonprofit organization in California can actually merge with another religious nonprofit without the consent of the attorney general. So those are really important protections in California and really important for organizations that are operating in California. If you are operated for religious purposes, that you be incorporated under the religious nonprofit corporation code and not the general nonprofit like public benefit code, because you actually get different rights and protections, as we see here, some of which can be very important. So this wouldn't have helped in this particular situation because these are not, religious nonprofit hospitals, but it's very important to keep in mind that you make sure that you know the laws in your state, especially concerning where the attorney general has oversight and can interfere in your nonprofit's major corporate actions and decisions to know, what does your state do? How intrusive is it? Because there are a lot of states, as I said, that have no oversight like this. Nonprofits can merge with nonprofits, and the AG, unless they see criminal activity, they don't have any, blanket right to intervene and sign off or to receive notice before they allow the merger. So state by state, this makes a big difference. The type of entity you are makes a big difference. It's definitely an issue that religious nonprofits uh, need to be aware of and often are not. So that's our little pitch for Napa Legal and some of our resources. We encourage you to check out the Faith and Freedom Index, and especially to look at the states where you're involved and what their major corporate action laws are concerning nonprofit organizations. For our last case today, we're going to go to Michigan. So Right to Life Michigan has filed a lawsuit against the state of Michigan, the Attorney General, Dana Nessel, who will be familiar to anyone who follows this podcast or religious freedom issues in general. So this is a lawsuit over an expansion of the employment non-discrimination laws in the state. So what happened here is Michigan recently amended its employment law so that abortion history is now part of the definition of sex for purposes of sex-based discrimination. So now supposedly employers are forbidden from taking an individual stance on abortion or their abortion history into account when making employment decisions. So the amendment further prohibits employers from advertising a preference for pro-life applicants when they are opening up job positions. I'm just going to keep going. Sorry. All right, we'll just go from here. So earlier this month, with the amended law, Right to Life sued the state officials, citing a violation of its rights to free speech and freedom of association. by forcing the pro-life advocacy group to associate with individuals opposed to its mission, which you point out in our weekly email that's coming out here today, Joseph. The new employment laws are, I think, pretty clearly unconstitutional under the First Amendment on speech as well as association grounds. So I want to talk about a couple things. First of all, I'll just note that this is not the first lawsuit of its kind. There's something similar going on in New York in the federal courts. But I want to begin with language from the very beginning of the Right to Life lawsuit. So here's the quote. Recent changes to Michigan's employment law force religious and pro-life groups to employ and associate with persons who do not share or live by and may even oppose the organization's beliefs on human life. This violates the First Amendment. Very pithy, very to the point. And there's just two legal issues that I see here. First, just the expansion of non-discrimination laws has gotten so completely out of hand that this needs to be pointed out every time we see, a new frontier being charted here. As the lawsuit says, Michigan's new employment law threatens these organizations. It redefines sex discrimination to include the termination of a pregnancy, which I don't know what kind of reading of sex when you think like, oh, I can't discriminate against a particular sex, man or woman, means, oh, I can't discriminate if somebody has like had an abortion or has particular thoughts on the goodness of abortion. That to me is a crazy expansion of what sex means, right? And then the lawsuit goes on, says now it is illegal to refuse to hire or recruit, discriminate, or deprive applicants of an employment opportunity because of their support for or decision to have an abortion, end quote. So non-discrimination laws, this is not news to anyone listening to this. They're originally introduced to stop discrimination on the basis of immutable characteristics, right? National origin, skin color, and so on. They're now being expanded beyond the first problem, which was expanding to choices like sexual preference and so-called gender identity, but now even to a person's beliefs and practices regarding the killing of unborn human life. Now, apparently, somehow, if you believe or certain things about abortion or have had abortion, you're now part of a protected class for non-discrimination laws. How did we get here? I mean, we've frankly been using, certain people in government have been using non-discrimination laws as an ever-expansive way to take control of hot-button ideological, religious, political issues and to demand conformity. And now we're seeing the natural result of when you can use these things to seize power, there are more and more ways to seize power. So on a related issue, right, these types of laws, not only are they crazy in how expansive they are, but they effectively prevent pro-life and religious and other kinds of organizations from existing effectively. Right? These kinds of laws force the organizations to hire or not fire people who are diametrically opposed to the founding beliefs and practices of the organization. Yes, they violate the First Amendment. I think that's pretty clear. I hope to see swift action from the courts on this, but they also violate common sense. Right? A mission-based organization has to have the right to hire people who believe in the mission of the organization. Again, common sense, right? Personally, I've talked about this with Joseph, I think off camera before, but I wouldn't expect like the atheist group Americans United for the Separation of Church and State or like the liberal ACLU to hire me as an attorney. And I would never argue that such decisions are impermissibly discriminatory. I don't believe and live in accordance with these organizations' founding mission. There's no reason that they should be forced by law to hire me, right? The same principle applies here. What Michigan is doing, it's not protecting against a class that experiences legitimate and widespread discrimination. This is enforcing a particular political and religious ideology on citizens and organizations that not only disagree among their members, but that are founded to do the exact opposite of what these non-discrimination laws are trying to impose. So I'll note, and then I'll end here, that in other areas, we've seen interesting developments on the church autonomy doctrine in Union Gospel Mission of Yakima out of the Ninth Circuit that has protected religious reasons for hiring based on certain beliefs and practices, notwithstanding non-discrimination laws. That's a new frontier, very promising. We've seen ministerial exception cases that are expanding to incorporate more employees of religious organizations as ministers. Seen that in the Fourth Circuit case of Billard in 2024, in the Ninth Circuit case of, Joseph, help me. I'm blanking on the
So
ministerial.
the Huntsman case.
No, not Huntsman. The ministerial exception case, World Vision versus McMahon. Sorry about that. So we're seeing good expansions of the church autonomy doctrine and the ministerial exception to keep these non-discrimination laws at bay. But they only refer to or apply to religious organizations, religious hires, religious ministers, depending on the doctrine we're using. So in a case like this, you might have a pro-life group that's not explicitly a religious organization, right? Or they are, but it's not their primary purpose. They might not have ministerial hires. They might not be afforded religious organization status sufficient to warrant church autonomy protections. So in a case like this, where the burden on the organizations is less about a religious choice and more about forcing a certain ideological conformity on a contested issue in our society, like abortion, I think the freedom of association claims are quite important to ensure that organizations that are not specifically religious still have the right to hire people who are aligned with their mission. Otherwise, again, you're forcing them out of the arena. If a pro-life organization that exists to promote the sanctity of life and to stop abortion is forced by non-discrimination law to hire people who have abortions, who support abortion, there's no way for those pro-life organizations to exist in any kind of meaningful or coherent way. So don't be deceived. This is not about legitimate discrimination. This is very much an attack on the rights of certain organizations with certain missions and really stopping their ability to exist. Joseph, I know my camera's cutting a little bit here, so I will throw it over to you. I'd love to hear if you have any closing comments on the Michigan Right to Life case.
Yeah, absolutely. Thanks, Frank, for explaining what's going on here in this case. I appreciated your remarks towards the end there about how we have these protections for religious organizations through kind of the growing ministerial exception, and especially in the latest Ninth Circuit opinion in Union Gospel Mission, even for the hiring of non-ministers just through church autonomy. Um, and kind of like you said, some pro-life groups are secular by belief, but some also that are kind of animated by Christian values or run by Christian organizations don't try to put out a Christian faith for practical reasons. Some might kind of be wary of kind of scaring away women that have had a past that's led them to be kind of wary of religion, or they also don't, make secular stakeholders not want to buy in, that sort of thing. So there are practical reasons that some pro-life centers avoid kind of the Christian label, but they don't have those same protections under ministerial exception or church autonomy because they're not religious. So like you said, these kind of free association claims are more non-religious reasons to protect the hiring of mission-aligned and mission-focused organizations is so crucial. And then secondly, I want to add a little bit to kind of how this law actually works. Now, I don't want to speculate on the intent of legislators, but there is some language in this Michigan law that reveals some of its true purpose, right? It's easy to read this law and think, oh, that makes sense. People change and employers shouldn't be able to say, I'm not going to hire you because you had an abortion 10 years ago. But that's not actually how this law was designed. Really, it's targeting pro-life organizations and trying to handicap their work. And there's two things both in this lawsuit and in some of the discovery process that reveal this. So for one, during the process of this lawsuit, state officials confirmed under oath that this law would require religious or mission-oriented organizations to hire people that disagree with their views as long as that applicant can explain the employer's views. Right? Think of a secular pro-life pregnancy resource center that has to hire a counselor who says, well, the center's pro-life and this is why, but personally, I think that abortion is great and this is where you can go to get it. That's the exact opposite of what this organization exists to do. And this Michigan law enables that or makes it so that pro-life centers might have to do that sort of thing. And secondly, and you mentioned this too, Frank, the law states that employers aren't allowed to advertise a preference for pro-life applicants in the job posting. If this was just about preventing discrimination against an applicant for their past, that part of the law would be completely absent, right? In no way does preventing pro-life organizations from advertising the fact that they want pro-life staff, in no way does that prevent discrimination. All it does is make it harder for them to hire people that align with their values. So it's easy to read this law and hear some of the media coverage and think, oh, this looks compassionate. You shouldn't punish people for their pasts. On one part that makes sense, right? A woman shouldn't be blocked out of the job market for a mistake she made maybe when she was a teenager. But that isn't what's happening with this law. What it's doing is targeting pro-life organizations and making it harder for them to have ideological consistency, save lives, and show women in vulnerable positions they have more options than abortion. This is not a compassionate effort to prevent discrimination. It's a way to promote the lie that abortion is the best and only option for women.
And with that, we thank you for joining us for this episode of the Napa Legal Podcast. One particular announcement, you can always follow what we're doing, see our events, our updates, support us financially at napalegalinstitute.org. But one announcement in particular, on April 23rd at the Catholic University of America in Washington, D.C., Napa Legal will be hosting our second annual National Lawyers Conference. So I won't announce any of the speakers because I'm not sure which ones are public yet, but we have a really impressive lineup of speakers. CLE credits are available. We'll have a lot of really interesting topics on the First Amendment, on nonprofit law, on religious freedom, on all the things that listeners to this podcast care about. So check out more information on the website, and please join us in DC on April 23rd if you can. And then we also, of course, appreciate it if you enjoy the content we're putting out here. Like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.